May it please the Court, my name is Bob Weber. I'm representing Helen Kirk in this matter. And today I'd like to address the question raised by the Court in its request for amici briefs, which is a slightly different question than I addressed in my brief. The difference being the request for the amici briefs asks whether or not the Court could close a civil commitment hearing at the request of the patient based on medical privacy considerations, implying that the hearings should be open unless the patient requested it and unless the Court made a finding that it should be closed based on medical considerations. I want to address it that way because I also agree with that position and with the position taken by the amici Mental Health Legal Advisors Committee and the Committee for Public Counsel.
Well, wasn't she just recently found not guilty by reason of insanity?
She was found not guilty by reason of insanity 4 or 5 years prior.
And isn't this in a way a continuation of the criminal proceeding?
No, Your Honor, I don't believe it is. The statutory scheme in Massachusetts makes it quite clear that after finding of not guilty by reason of mental illness, the initial commitment hearing is conducted by the court that conducted the criminal trial. But the legal standard that court must apply is the same standard that they apply to someone who is civilly committed under Chapter 122.
I understand that, but I mean in terms of the public's right to know and interest in the case, this is a person who's may well have escaped or avoided a life sentence because of her mental condition. And isn't the public, therefore, entitled to know what is going to happen to her?
I'm a little reluctant to adopt your conclusion that she escaped a life sentence.
Well, she avoided it. It was certainly a potential.
It was a potential, although she was found not guilty by reason of
But
mental
she
illness.
wasn't found not guilty.
Well, no, she admitted that she had committed the act.
Okay, so
I mean, that's part
okay.
of the finding.
Okay.
But I guess you're changing your position in your brief, I take it, because your brief and the MLAC brief are not coming out at the same place. But if you're saying that you agree with MLAC, that's a somewhat different place.
It is a somewhat different place because I think that that's where the law goes,
okay.
quite frankly.
So, but
to address Judge...
Okay, let me just ask you this. In response to Justice Cowan's question, though, wouldn't it be your position that whatever the answer may be in this case, I guess this is my question, are you saying that if a person in your client's position requests that it be closed, then the judge should close it without questions, or is that a factor, an important factor, but a factor among others that he or she should be considering in deciding whether or not to close it?
Your Honor, it's not my position that the law does and should go so far as to give the patient, the client, veto power over whether it should be open to the public. It's my position that and the cases seem to support the theory that the trial judge can make findings that weigh the public interest in opening the case against the patient's privacy rights and the medical considerations based on the individual case, and can therefore, after making such inquiry, individualistic inquiry into each case, make a decision that in this particular case that the hearing or part of the hearing should be closed to the public.
Excuse me.
And just to address Justice Cowan's issue, which I think is an important one, I think the fact that she was found not guilty by reason of mental illness of a capital crime as opposed to a lesser crime is certainly part of what goes into the court's weighing of the issues when they're balancing the public interest against the private industry. In fact, the Supreme Court in New Jersey, in a very lengthy case, Edward S., which I think was cited in all the briefs, specifically addresses that issue. Now, in Jersey, their statutory scheme was slightly different from ours in that they had a different statutory scheme for the commitment of people who are not guilty by reason of mental illness, as opposed to a statutory scheme for the commitment of people who were straight civilly committed. And the New Jersey court specifically, because the case they had involved a similar type of situation, fact situation, specifically created a strong presumption in favor of opening hearings where the underlying criminal offense was a capital offense, and stated quite clearly that that was a strong reason to keep it open to the public. But the court did conclude, and if I can quote, the strong presumption to have the effect of foreclosing in-camera hearings is an almost insurmountable obstacle. But the court pointed out the trial courts retain the power for good cause to order that any periodic hearing or part of such hearing be closed, and the decision calls for sensitive weighing of all of the factors, including the patient's continuing interest in privacy and the public interest in open proceedings in these matters.
But didn't the court specifically say that unless the committed person shows that the in-camera proceeding would not undermine public confidence in the judicial system? I think they said that in the New Jersey case, and that's my concern here, that public confidence is undermined when they see somebody who admittedly killed someone walk out because the person is going to be committed, and then further proceedings are not open to the public.
On the other hand, Your Honor, I point out that the Patriot Ledger, in its brief, addressed the fact that and alleged that Ms. Kirk was seeking to close the case because of what they anticipated as a groundswell of opposition to her, quote, accelerated release. And it seems to me the newspaper itself describing in its brief what could be a groundswell of opposition, whether it's there or not, I don't know, but it seems to me that that in and of itself describes some of the risks that could happen in order, I mean...
But judges aren't supposed to be
judges
influenced by
are
a
not.
Groundswell of public opinion. If they are, they shouldn't be there.
I understand that, but it does happen.
So what rule would, if we adopt your position, what's the rule going forward in cases like this?
It seems to me that the rule going forward in cases like this, and I would suggest in other commitment cases, is that the court should have a presumption of open hearings.
So you start with the presumption of an open hearing.
Exactly. And then that if the patient can seek privacy, patient doesn't seek it, you don't have that issue, must advance an overriding interest that they are likely to be prejudiced, and that the public disclosure of their psychiatric treatment, including confidential communications between her and her therapist, will have an adverse effect on her and an adverse effect on her treatment. I think it's important to understand that Ms. Kirk, anybody in her position, after they're found not guilty by reason of mental illness and is committed to a locked psychiatric hospital, is there for purposes of treatment.
Well, Mr. Weber, then if a judge agrees with the patient's point of view, then they'll close the hearing. If they don't, they'll have an open hearing. And then the question is, has the judge abused their discretion?
I don't think so. I think, the matter of fact, Chapter 123, Section 36A, which I cite, which basically is the Massachusetts statute that requires that all reports and communications submitted to the court during a commitment hearing shall be private unless at the discretion of the court they're free to be open. So that the statute today provides for that. I've never seen it raised in any court, but it's in the statutory scheme that we have right now.
But there's a similar provision with regard to SDP in 123A with regard, say, to qualified examining reports, but we don't close the SDP hearings to the public. So why should this be any different from a civil commitment hearing based on sexual dangerousness as opposed to to one which is based on non-sexual dangerousness?
I think, first of all, initial SDP trials under Section 12 are brought by the petitioner. After that, the patient is raising his own mental state.
Except that, like the SDP cases, the commitments that at least start under Section 16 of Chapter 123, this makes them a little bit different than commitment hearings that don't start under Section 16. The question of the predictability of the dangerousness of a person becomes better established once there is a conviction for a crime, that at least for some period of time there's got to be some very strong inference that this person is dangerous. How long that inference fades out into time, I don't know. It may depend on the nature of the crime that was committed, and it may depend on the way the crime was committed. But once there's a conviction for a crime, it seems to me that the question of predictability of dangerousness weighs very heavily against the person committed, and the public's interest in seeing that this person is not released becomes very compelling.
Oh, I would suggest, Your Honor, that at least in my experience in doing mental health civil commitment cases, the fact that somebody was found not guilty by reason of mental illness of a crime, even a violent crime. I have represented civilly committed patients who were never charged, who all the evidence shows committed almost as violent an act as someone who was found not guilty by reason of mental illness. And I'm not suggesting at all that the violent act that they committed, whether they were charged or not, isn't relevant history to the determination by the trial judge at the commitment hearing as to whether or not the person is likelihood to cause serious harm to somebody else.
Does the decision to close the hearing make any difference if the issue of the person's dangerousness is one that is self-directed? In other words, they're suicidal as opposed to the danger to the public.
I don't see why it would.
How do you support your position in face of the fact that the legislature has declared that certain proceedings shall be closed to the public, such as juvenile proceedings, and they have not declared that these proceedings shall be closed to the public? Shouldn't we read from that the legislature has spoken and has said that these are to be open proceedings?
I agree with that, and it seems to me that the presumption that they're open can be inferred from that, although Section 36A implies that the legislature also gave the courts the right to close the hearings if the interests of justice required. And it seems to me our cases
You mean
also,
at least when the records that could be
well,
closed are
it
being
says
discussed?
records and reports, and it seems
But since it very clearly only refers to records in Section 36A, it doesn't refer to hearings being closed.
it refers to reports.
Records and reports.
Well, but a report is not only a written report, but a verbal report. A doctor testifying about his patient at the hospital is reporting about what the patient was doing.
But if the legislature wanted to say, and the testimony, they would have said the testimony. They use the word report, and nobody's supposed to get up and read his or her report.
But it becomes the same thing. It becomes the same thing. I wanted to address the SDP question just very briefly again, because it seems to me, particularly in a Section 9 hearing in an SDP case, the patient is saying to the court, I want to be discharged. And Section 9 hearings, as this court is well aware, the patient must cooperate with the qualified examiner's report. If he doesn't, his petition is automatically dismissed. In this case, the patient is not initiating anything. In fact, in this case, the Department of Mental Health felt she was ready for discharge. She is not putting her mental state at issue. The district attorney is required to prove beyond a reasonable doubt that she is mentally ill. She is not saying to the court, I want to prove I'm sane. That's a major difference between a civil commitment case and an SDP case where the patient is saying, particularly Section 9, and those reviews are not required. The patient has to initiate it. And the patient is saying, find me no longer SDP. I am putting the fact that I have received treatment in front of the court. And it seems to me by so doing, one could argue that they're waiving their privacy rights.
Could I just ask, I'm sorry, I just had one question if I could. Sure. I'm not certain that there's much disagreement. I mean, your point, I take it, is we have a Constitution that says these things are presumptively open. We have a statutory scheme that says they're open. And if I, patient, want to have it closed in whole or in part, it's my burden, and I've got to show an overriding interest why it should be.
Correct.
Is that right?
Yes.
Thank you, Coach.
Good morning, Mary Lee, Assistant District Attorney for Timothy Cruz, District Attorney. The Commonwealth's position is that the Constitution starts with the presumption of openness. And we see these cases across the board, obviously, in the criminal sector, most recently with this court's decision in Cohen and the U.S. Supreme Court decision in Presley.
Does that mean that these should be in courtrooms, not in hospitals?
There's a statutory provision in Chapter 123, I believe it's Section 5, that says that it takes place, the court sits in the hospital. And
For all of these proceedings under 16?
yes, and I believe this is a courtroom in the hospital.
The statute says it has to take place in the hospital?
It says it may, I believe, and the statute's in my addendum, but I believe it says may. And that's for the convenience. It's more of a convenience thing than anything else, so that...
Hard to get the public in there, though.
Well, in this case, it was the hospital that prevented the member of the press from going in at all. But the public was aware of it and was attempting to get in the guise of one reporter from the Patriot Ledger, and the hospital prevented his admission to the courtroom that sits within Taunton State Hospital, and the district attorney's office called it to the judge's attention prior to the hearing on the motion for closure by Ms. Kirk. At that point, the judge in the district court, Judge Cunningham, asked for the reporter to be permitted in, and he was permitted in and was permitted to report on the matter. And the reason Ms. Kirk did not object to the closure of that preliminary hearing is that her private records, her therapies would not be discussed in the preliminary motion for closure. Taunton State Hospital still objected to the open proceeding at that preliminary motion, as can be seen in the Commonwealth's supporting affidavit, as well as the transcript that has been provided by the district attorney's office.
What kinds of logistic problems, if any, do we have if the hearings were to take place in a courtroom, in terms of hospital staff having to escort these the patients, segregation of the patients from other people? Are there large numbers involved?
Well, I think you can see some examples of the numbers in the amicus brief from MLAC that say, there are, and as well as the DMH brief that say there are many of these petitions that are heard, and that if there are required motions for closure in each one, that would be, they say numerous. We don't get many. I think there is a reference to hundreds of cases in the DMH brief. Those hundreds of cases are all of them civil commitments, as well as the cases that arise from criminal proceedings, then move on to civil commitments from those criminal proceedings.
But is this hundreds of cases on a single hearing day, or
No,
over the course of a year?
No, I don't know that there were even any other hearings being heard the day of Ms. Kirk's motion, although I was not there, so I can't speak to that. I think the idea is we want doctors and treating physicians in hospitals. You see the same kind of policy theory in the medical records and hospital records statutes that come in, like business records in criminal cases or other types of cases under Chapter 233. So I think that it's Chapter 123, Section 5, that has the hospital have a courtroom where people sit is more for convenience of moving people in and out of the courtroom for their proceedings. And so they can do numerous hearings if necessary on one day. So I think it's a convenience portion of the statute. But the brief for MLAC suggests that the more formality, the more public a courtroom is, the more that you have you don't have people sitting at a conference table, you actually have a courtroom, the better it is for everybody. And the district attorney's office agrees with that proposition. We believe the Constitution starts from a presumption of openness, and we'd ask this court, if you make any rule, that you also start from the presumption of openness. The federal common law, as noted in the Gannett case, this presumption of openness goes back far beyond our Constitution, back to the King's Courts, Cowley versus Pulsifer from this court.
So when should it be closed? You said a presumption, that
Yes.
leaves open the possibility that some or all of it may be closed. What is your view on that?
I think we would look to Presley versus Georgia and Waller versus Georgia. The party seeking closure has to make a sufficient showing. I cite that in my brief on page 18. The party seeking to close the hearing must advance an overriding interest that is likely to be prejudiced. The closure must be no broader than necessary to protect that interest. And the trial court must consider reasonable alternatives to closing the proceeding, and it must make findings adequate to support the closure.
So if the patient says this will adversely affect my treatment, would that be sufficient?
I do not think that would be sufficient, and I don't think even the amicus briefs say that. I think.
So what would be a sufficient showing?
Well, in a general case, I think if you had a place where the individual was able to make a showing that it would be great prejudice to them, and then on the other side, you did not have a significant legitimate interest in the hearing, then...
Why is it not prejudice to them if their treatment in the future, their likelihood of addressing their suicidal tendencies or homicidal will be adversely affected? Why is that not prejudice?
It may be prejudice, but does that entirely override the public's interest? And you see a balancing like that at the Edward S. case out of New Jersey, that the public does have an interest in this case, which derives from a capital case, a murder case, where there can be great harm if everyone's wrong. There can be great harm upon a person's release if their mental illness is not
So how would you ever
properly
know if a
satisfied.
judge made a mistake in a hearing like that, with the balancing?
Well, I would suggest in Edward S., what the court came down to is that when this case derives from murder, the public's interest is so great that these hearings should never be
Whenever
closed.
a murder is involved, the public always, that trumps the
That trump-
individual's privacy.
Right. And that's how Edward S. came out. And I would note in Edward
That'd be
S.
all capital offenses or only murder cases?
I believe all capital offenses, but in Edward S. was murder, and I was looking at it for murder because.
So is that your
murder.
position?
This-
That not, it isn't even presumption, it's an absolute presumption?
Well-
An irrebuttable presumption that if it's a murder case, it needs to be open?
I note that Edward S. is only persuasive authority, but the district attorney's position is that it is correct and that this court should be persuaded by that authority because the danger of harm to the public is so great in a murder case that if such actions are repeated, then the public certainly at least would be able to protect itself upon a person's release,
And
as
what
they
if,
should be.
what
able
if
to.
the murder occurred 20 years before the hearing date? Does that weigh into this at all?
I think it should, because, this isn't about a person not getting a hearing or not having anything weighed in their favor or against their favor. This is about a person's rights being considered while in the public forum. And there's nothing wrong with that. We want the eyes of the public on us as prosecutors. Why is the district attorney's office bringing this petition for recommitment? Did Taunton State
Well, there
Hospital...
may be a time when the district attorney is not opposing the petition, and you want the public to be aware of that.
If we weren't bringing a petition, then the person would get released. So that would not be done actually in a courtroom. The person would be released. But under Chapter 123, we are given the collective authority to move forward. Under Chapter 123, Section 9, any individual can petition the court for a person who is in who's committed to the hospital situation. And in that, the legislature has suggested that in and of itself, that the public has an interest in these cases. And it's good that the public watches us, and it's good that the public gets to hear, what did Taunton State Hospital do that makes her now, in 2009, at the time now 2010, to be released, when only in 2007 she was found NGI, and only in 2005 she had killed her son. The public should be able to hear how Taunton State Hospital has expended its public resources, if they have complied with proper medical procedures, and what they have done to treat her now, and what will be done in the future. I mean, is she walking out the door to be homeless, or is she walking out the door to treatment? The public should hear that.
But why is it all or nothing? I mean, why can't a judge say, I'm going to hold the hearing in a public forum, but there may be some bits of information so sensitive, it may, for instance, reveal an abuse of the individual and his sister, who may not even be at issue, and that sister may not want the fact that she was abused as a child sexually to be made a matter. Why can't the judge say, I'm going to, as to this portion, I'm going to close it as to this portion because this really poses special risks? Why can't a judge do that?
He can, or she can, under the Waller versus Georgia procedures, because it must make findings, because the court must consider reasonable alternatives to closing the proceeding. They can close portions of the proceeding, or they could, for example, Chapter 123, Section 36A says that the records shall be private except in the judge's discretion, and so the judge could say, oh, this is touching on these records. I can see why these records should be private, and so this portion of the testimony or these exhibits will not be admissible to the public.
So how far are you from Ms. Kirk's position?
Well, I think when we wrote our briefs, I felt that we were very far, but hearing counsel's argument today, I think we are, in fact, very close, that we start with the presumption of openness, that there is no statutory provision that requires or permits closure. Therefore, you're not stuck, but you are governed under the Waller procedures, and that it is Ms. Kirk's duty, if she wants closure, to ask for closure and to support that closure, and then it is the judge in his or her discretion who decides if closure is appropriate and exactly how much closure is appropriate, and so it is not an all or nothing standard. And then the policies of Edward S. are served because the public proceedings inspire confidence in the judicial system. They give the public the interest that it deserves. That interest does not just protect the district attorney's interests or Ms. Kirk's interests alone or the court's interests alone. It protects all mentally challenged persons who are subject to the system. As pointed out in the MLAC brief, in the past, these were not even court proceedings. They were done in writing. A husband committed his wife just because he could pay the bill. And in another proceeding, the selectmen of a town and the person's family committed him, and those were said to be fine under this court's decisions at those times. And what a dangerous situation that would be for the government to be able to quietly, secretly and privately essentially imprison these people. It is the public's eyes on me, on you, and on Taunton State Hospital that protects Ms. Kirk, all people like her, and all people in civil commitment proceedings. And it is their interest, as established by the legislature, that we are seeking to protect. And I would rely heavily on the reasoning in Cowley versus Pulsifer, which was also noted in this court's case in Ray Charlene, that while these problems of the individuals might be embarrassing, might not be the best thing conducive to their treatment, they are essential to having government actors acting appropriately, and that we are subject to the rules of law and not the whims of individual government actors.
You've just said that you think you're very close to where Mr. Weber now is, or Ms. Kirk now is. Is there a difference between, I mean, I'm not clear about whether you're saying it's a sort of general rule of presumption of openness, it's up to the person seeking closure to show an overriding interest why it should be closed in whole or in part. But are you saying that capital cases, which here is murder cases,
Yes.
first-degree murder cases, are in a category by themselves?
I would suggest that in a capital case, like in Edward S., and I would note in Edward S., the New Jersey statute actually required that the hearings be closed, and the New Jersey Supreme Court said in murder cases, not only is there a presumption they should be open, the interest of the public is so great that it would be very difficult, if not impossible, to overcome that. I would suggest in murder cases here, we have the presumption of openness, we have the legitimate public interest, and that the judge still retains the discretion to withhold certain records under Section 36A, if appropriate, and if some testimony might touch on those same kinds of topics that are within those records, for example, an expert's reliance on records within 36A, the judge would have discretion to protect those through a protective order or a non-release. In the same way that a judge has discretion in a criminal case to hold back the victim's name, which is required by statute, that it would be wrong to release her name. So I would suggest that that is proper to leave to the discretion of the judge. I see that my time is up. Unless there are any further questions, I would ask this court to affirm the district court judge's ruling.
Thank you, Ms. Lee.
Thank you.